Good evening. For those of you who don't know me, I'm happy to see a lot of familiar faces, but for those of you who don't know me, my name is Devon Westhill. I'm the president of the University of Florida chapter of the Federalist Society, and I'm also the chairman of the executive committee for this fine event. On behalf of our chapter of the Federalist Society, the UF Devon College of Law, and the Federalist Society organization, I'd like to welcome you to the 33rd Annual National Student Symposium in the great state of Florida. That's a clapping moment. So it really is a wonderful pleasure for the University of Florida to host this prestigious event for the very first time. Now, traditionally at these events that I've been to and at the ones that I've seen video of, there's the obligatory apology for the snow and the ice from the Ivies. I'm very happy to not have to apologize for that, but it is cold for us here, although warm for a lot of our guests, I know. So enjoy the weather. It's going to get even nicer tomorrow, I promise. The jab at the Ivies is really only because, and I think many people here know, that this event, with only one exception in its history, has been hosted at a school ranked in the top 15 in the nation. I want you to know that the importance of the fact that it's being held at the University of Florida for the very first time, in the state of Florida for the very first time, at a school not ranked in the top 15 in the nation, is not lost on the executive committee. We think that we've organized one of the very best student-run academic conferences ever. And by Saturday night, we really hope that you all agree with us. To that point, we've assembled a tremendous lineup of speakers, some of which you see on the stage with me right now, on a topic that is the most timely that you could possibly think of right now. We really didn't envision how privacy, security, and freedom and the intersection of those topics would really take off over the last year when we chose this topic. We're confident that it'd be at the forefront of people's minds and the consciousness of Americans, but it's just really taken off, and we're glad that we have the speakers that we have for this event. They're tremendous. The only thing that seems to be more timely right now, or at least over the last few months, is me getting emails and requests to have Edward Snowden as the keynote. I don't know where that started, but he's not. He turned us down for South by Southwest. Anyway, I have numerous people to thank for their help with organizing this, but I want to get started with just one person. I'll save all the other thank yous for the banquet. The UF College of Law administration has been tremendously helpful to us in organizing this and executing it, ensuring that this event is successful. You'll see some of them throughout the course of the next day and a half, and I encourage you to thank them for their help with this. I approached Dean Bob Jerry, the dean of the law school, last spring about my ambition to do something unprecedented, to bring the Federalist Society National Student Symposium to the University of Florida. This was, obviously really pie in the sky given its history, but he was immediately supportive of my ambition, oddly enough. A random student just came to his office. But right from the beginning, he threw the support of his administration behind us, and for that we're tremendously grateful. Dean Jerry has had a distinguished legal career capped off by his service here at the University of Florida Devon College of Law. For that, we're also very thankful. However, he announced earlier this year, for those of you who don't know, that this academic year he's stepping down as dean of the law school after 11 great years of service, great years that will be respected for long to come, and he's going to be greatly missed, especially by me. We've worked very close together for this to make this event happen. You guys didn't come to hear me talk. Please join me in thanking and welcoming Dean Bob Jerry up to the stage.
Thank you, Devon, for those very kind remarks. Let me begin with my welcome to all of you. A welcome to the conference, a welcome to the Devon College of Law, and a welcome to the University of Florida. We're delighted to have the National Federalist Society Student Symposium being held here. Devon gave you all the firsts. Let me say that I'm personally very proud to be Dean of the Law School here at the time our students did the work, make all those firsts possible. I know that many of you came some long distances to be here. For those of you making your first visit to Gainesville, Florida, let me tell you that you're on the campus of a comprehensive land-grant research university, the state's oldest, and we're only one of 17 public land-grant universities in the nation to belong to the AAU. Today we have about 50,000 students on the campus, nearly 4,000 faculty, 16 colleges that offer 100 undergraduate degrees, 200 graduate programs, and 5 professional degrees, including law, and more than 200 research centers and institutes, all on a campus of more than 2,000 acres with over 900 buildings. And with all those academic and programs and research centers here, you may not be aware we also have athletic programs at the University of Florida. We have a basketball team here that has had some success during the last 7 or 8 years, and they're doing reasonably well right now. We have a football team that plays in a small stadium that's a short walk from where we are right now. And there are 11 other Gator sports teams that together have won 31 national championships. So with all the media attention that the law school's moot court and trial teams get, and all the attention the media gives the UF Law Federal Society speaker series and various academic, I always like to mention sports because it can get crowded out on the field of public awareness, and I like to mention that so they're not overlooked. I hope that you will have the opportunity to visit the law school campus while you are here. We take up about a city block on the northwest corner of the university. We stress preparation for leadership. We're proud of the fact that UF Law alumni have been president of the ABA 5 times since 1973, and that we are tied for 7th nationally among all law schools in the number of our graduates serving as federal district and circuit court judges. And there are many other statistics like this I can recite, whether I'm either awake or asleep. But what I'm especially proud of, and I want to stress, is I'm so proud of our students, and I make special note of the student leadership of the Federal Society chapter here at UF. This student symposium marks many firsts, but we would not be here tonight without 2 things. First, the support of the sponsors. We are extremely grateful for all the sponsor support, and especially that of the James Madison Institute, a Florida-based public research institute doing some very significant work, and a UF alumnus named Rob Goodell, whom I hope you'll have the chance to meet. And let me also commend the chapter's faculty advisor, Professor Steve Willis, for his leadership and good work. But the other reason, the second reason we're here, is because of the UF Law students, and especially Devon Westhill. All of these students came up with the idea to compete to host the conference. They prepared the proposal. They did the hard work in planning it. And I can't say enough about these students and the excellent leadership provided by the chapter here at the University of Florida. And I want, on behalf of all of us, I want to thank them for their good work in doing this. Last but not least, I hope you have some time to have some fun in Gainesville while you're here. This is the home of Tom Petty and some of the Heartbreakers. Stephen Stills, Don Felder, and Bernie Ledden of the Continentals, although you might know that band, the Continentals is when they started here in Gainesville. They're now known as the Eagles. Sister Hazel, In Crisis, and many more. Great music downtown, take in the nightlife, although do so responsibly. Go see some alligators at Payne's Prairie, although do so responsibly. See them during the day. Don't go at night. That's a bad idea. If you brought your pet dog or cat to Gainesville, don't take them to see the alligators. That's a bad idea. Go tubing at Chautauqua Springs or take in one of the museums here. Have some fun while you're here, but most importantly, have a wonderful conference, and please accept my wishes for a great symposium and my welcome to Gainesville and the University of Florida. Thank you very much.
sorry, I don't have much to say. There's a lot in the program and on our website about with biographies and so forth. We got a little bit of a late start today, but at this time I'd like to welcome Judge William Pryor to the podium to get us started.
Good evening. Dean Jerry, it's great to see you again. It's great to be back at the University of Florida. The Dean will well remember that my last visit here was a very pleasant one. It was in the fall. It was on a Saturday. And I welcome you to Tuscaloosa this coming fall. We'll be hosting the Gators in Bryant-Denny Stadium, and I hope to leave with a smile on my face again. Welcome to the first panel discussion for the National Student Symposium of the Federalist Society. This discussion is entitled Balancing Privacy and Security. The roundtable will address a wide range of issues and potential solutions to the challenges associated with balancing privacy and security in an increasingly technological world. In an era where individuals increasingly entrust their data to third parties, how can the right balance be struck between the government's need to collect information and the individual's right to privacy in that information? Among other topics, this roundtable will consider whether the Fourth Amendment adequately protects an individual's right in an era of rapidly advancing technology, and whether Congress should play a more active role in regulating that technology. For this discussion, the Federalist Society, as usual, has assembled a distinguished panel of experts. I will introduce the panelists in the order that they will speak. Our first speaker will be Steve Bradbury. Mr. Bradbury is a partner in the Washington, D.C. office of the law firm Deckert, LLP, where he has a general litigation, administrative law, and an appellate practice. During the Bush administration, Mr. Bradbury was the head of the Office of Legal Counsel in the Department of Justice, where he served from 2004 until 2009. There he led the legal effort for the Justice Department that resulted in the initial FISA court approval of the NSA's telephone metadata program in 2006, and was extensively involved in the collaboration between the executive branch and Congress that produced the FISA Amendments Act of 2008. Mr. Bradbury served as a law clerk to our circuit justice here in the 11th Circuit, Justice Clarence Thomas on the Supreme Court, and to Judge James Buckley on the D.C. Circuit. He is a graduate of the Michigan Law School and Stanford University. Our second speaker, Ted Olliott. Mr. Olliott was general counsel of Facebook from 2008 to 2013. Among other highlights of his time at Facebook, Mr. Olliott directed the company's response to the June 2013 media stories about the PRISM program. He led the negotiations with the government that resulted in Facebook becoming the first company allowed to include all national security-related requests in its transparency reports, a practice that has now become the industry standard. He also worked in the administration of President George W. Bush, first at the White House and later at the Department of Justice as Chief of Staff to Attorney General Al Gonzalez. He was a law clerk for Justice Antonin Scalia and for Judge Michael Ludig on the Fourth Circuit. Mr. Olliott received his J.D. from the University of Chicago Law School and his undergraduate degree from Harvard. Julian Sanchez will be our third speaker, is an American libertarian writer living in Washington, D.C., currently a research fellow at the Cato Institute. He previously covered technology and privacy issues as the Washington editor for Ars Technica. Mr. Sanchez is also a contributing editor at Reason Magazine. He has a weblog at juliansanchez.com. You can go there now. He's also blogged for Reason and The Economist. He is a graduate of New York University, where he studied philosophy and political science. Rachel Brand is the Vice President and General Counsel and Chief Counsel for Regulatory Litigation at the National Chamber Litigation Center, the litigation arm of the United States Chamber of Commerce. Ms. Brand is also a member of the U.S. Privacy and Civil Liberties Oversight Board, an independent bipartisan agency that provides oversight and advice to other federal agencies about the impact of counterterrorism activities on privacy and civil liberties. Ms. Brand's appointment by President Obama was confirmed by the Senate in 2012. She previously practiced law with Wilmer Hale. She also has extensive government experience, having served as the Assistant Attorney General for Legal Policy at the Department of Justice after being confirmed by the Senate and appointed by President Bush in 2005. Earlier in her career, Ms. Brand served in the Office of White House Counsel for President Bush. Ms. Brand served as a law clerk to Justice Anthony Kennedy and for Justice Charles Freed on the Supreme Court of Massachusetts. She graduated cum laude from Harvard Law School and with high distinction and honors from the University of Minnesota. And our final speaker, Professor John Steniford, is an associate professor of law here at the University of Florida Levin College of Law. Professor Steniford's areas of expertise include criminal law, criminal procedure, the Eighth Amendment, sentencing law and policy, and evidence. His research focuses on constitutional limitations on the governmental power to inflict punishment. More specifically, Professor Steniford's current scholarship focuses on the historical underpinnings of the Eighth Amendment's cruel and unusual punishments clause, as well as the due process clauses of the Fifth and 14th Amendments. Before joining the faculty of the Law College at the University of Florida, Professor Steniford practiced criminal law for several years, first in private practice with the law firm of Winston Strawn, and then as a federal prosecutor. He also clerked for a federal district judge. Professor Steniford is an honors graduate of the Harvard Law School and holds a master's in arts from Harvard University and a bachelor's from the University of Virginia. Now, each panelist will speak for about 10 minutes before responding to each other. I feel at some disadvantage. I don't have my red and green lights that I'm usually able to administer for those who speak over time, but I'll do my best. And we'll then open it up to some questions from the floor after they've had an opportunity to respond to each other. So, without further ado, Mr. Bradbury.
Judge, thank you very much. Appreciate being here and appreciate the law school hosting. The title of the panel is Balancing Privacy and Security, and I happen to think our Constitution does a pretty excellent job of achieving that balance. On the one hand, national security in its most fundamental sense, by which I mean protecting the United States and Americans from foreign attack, like the attacks of 9/11, is an imperative. And that's in large part because without effective national security, we don't have any of the other freedoms enshrined in the Constitution, not in a practical sense. And of course, looking out for the national security is undeniably a legitimate and proper function of the central government. And I think all Federalists, all members of the Federalist Society can agree with that fundamental proposition. In the war on terror, of which 9/11 is a cardinal example, signals intelligence or communications intelligence is a critical element in our ability to protect the country. Discovering the hidden cells of terrorist organizations requires diligent communications intelligence. That's the mission of the National Security Agency. But there's another equally important imperative, and that's in the Fourth Amendment. And the Fourth Amendment protects all Americans against unreasonable searches by the government. Prior to 1967, the Supreme Court interpreted that to mean freedom from physical invasion or trespass of your private sphere, like your home or physical property. In 1967, the court changed or clarified the standard to be invasion of a reasonable expectation of privacy. That's the definition of a search under the Fourth Amendment. And I think the fundamental principles of the Fourth Amendment mesh nicely, because I think the founders, James Madison, understood what he was doing, mesh nicely with the needs of the national government to protect the country from foreign attack. And I think they're in well balance. They're in good balance. I don't think there's a conflict between the needs of national security and the actions of the National Security Agency, and the protection of the legitimate, reasonable expectations of privacy of Americans against unreasonable invasion by the government. I think there's a harmony there. Now, in response to political calls for greater protection of privacy, particularly in an age such as we're living in when technology is rapidly developing and all of our lives we're able to extend our lives out over the internet and through digital communication. We share our personalities and our thoughts more broadly than ever, globally, really. There's a call for greater and greater protection in some quarters. And Congress responds to that, appropriately so, through legislation that provides special additional protections over and above the baselines of the Constitution. Sometimes those statutory protections, however, can infringe on the functions and mission of our intelligence agencies in protecting the country against those foreign threats. And we see modulations over time. Sometimes Congress goes a little too far in ratcheting down and restricting what can be done, and other times it's modified, it's modulated. And we've seen that since 9/11. And I think the current state of statutory law as an overlay on the fundamental principles of the Fourth Amendment has it just about right. I think we're in a good equilibrium, and I think the activities of the National Security Agency, which I believe are fully consistent with the statutes that Congress has passed, and I believe fully consistent with the Fourth Amendment, provide a good balance. But we're in a time when there's a great debate going on because of the disclosures made by Edward Snowden about programs of the National Security Agency and exposing those to public debate, and of course to our enemies, to those who we're trying to find through these programs. The disclosures, I think, have been hugely damaging to our national security, but at the same time, I think the debate is extremely healthy, and it's really a historic debate. And I think the programs of the National Security Agency that have been exposed by the Snowden leaks and have now been further disclosed through declassification and disclosures by the government and the public debate provide a good model for discussing first principles under the Fourth Amendment and some of the basic concepts that inform a debate about balancing national security and privacy. And if you look at the two principal programs of the National Security Agency that have been disclosed, they really nicely illustrate, and the legal debates about the programs nicely illustrate some fundamental concepts under the Fourth Amendment. And they inform the debate about whether Congress should go significantly further than it's gone in terms of restricting the activities of the intelligence agencies. And it's a hugely important debate of historic proportions, and I think that it's an interesting time to be a constitutional scholar and to be a student of national security and national security law. Let me describe very quickly the two major programs and then just begin the discussion of how I think they illustrate a couple of fundamental principles under the Fourth Amendment that I think all Americans should know more about, and I think this debate is helping inform. Of course, the two programs are one that what everybody's is pretty familiar now from the public debate, the telephone metadata program. The other program, which is sometimes referred to as the Section 702 program that involves the PRISM collection, is a collection of content of communication that's targeted at non-U.S. persons who are believed to be located outside the United States. So it's focusing on international communications. The first program, telephone metadata program, does not involve anybody listening in on any phone calls. It doesn't involve any information other than tables of numbers, what phone number has called what number, what time, and for what duration. This is called metadata, which means data about communications, not the communications themselves. In this case, This data is collected by the telephone companies for their billing purposes and kept in their databases for a period of months. Each company has its own collection for its own subscribers. They use it for billing and resolving billing disputes. What the NSA does is, under an order approved by a court of the Foreign Intelligence Surveillance Act court, it collects this data in mass, in bulk, from multiple phone companies. Again, the data is just the phone numbers. And it preserves the data in a database. It puts it together so it's in a common format that can be efficiently searched, and secures it in a database which it only uses for counterterrorism investigations. And the only way it can access the database under the court order is when it has reasonable suspicion that a particular phone number is associated with a foreign terrorist organization. And then it queries the database. It essentially asks the database what other numbers have called this number and what numbers has it called. And the output is simply a list of numbers. They then do it again a second hop. If they have a suspicion about a particular number, they would do it a third hop. Well, the president has ordered them to stop doing that. They're not doing that now. But they collect a basket of numbers that are interconnected through calls, and they analyze them. And the purpose of it is to discover new phone numbers that we didn't know about before that may be associated with one of these terrorist organizations. Perhaps it's a cell we didn't know about operating in the United States. And of course, those numbers in the United States that may be in communication with these organizations, those are the most important numbers to discover. And then if the NSA believes it's identified a new number that looks suspicious associated with one of these organizations, it will tip it to the FBI. It's then up to the FBI to follow up and try to discover more information about that person, that number. And at a certain point, if the FBI has probable cause, based on what they've learned, they can get a wiretap, a search warrant, etc. This, as you can tell, is the beginning of the investigation. And I think this leads to the first critical principle under the Fourth Amendment, which is the Fourth Amendment flexibly enables law enforcement organizations, or in this case, intelligence agencies, to put together the building blocks of an investigation to start an investigation. And here the critical difference is between transactional records or metadata and the content of communications. And the Supreme Court has made it quite clear that this kind of data, which is generated by companies that are providing services, it's like when you cash a check. When you make a phone call, there's a record that the company generates. Those business records are not records that you control or have a reasonable expectation of privacy in, and they don't reveal the content of your private communication. And so agencies or law enforcement departments, consistent with the Fourth Amendment, are able to obtain business records like that they need to conduct an investigation when the records are relevant to an investigation. It's the same standard, for example, that regulatory agencies use, or grand juries, when they issue subpoenas for documents, business records, which are not approved by any court. The difference for the National Security Agency is, under the Foreign Intelligence Surveillance Act, it must get a district court judge approval. So it has to get court approval, which is a big difference. But the point is that these business records, in which the Supreme Court has said there's not a reasonable expectation of privacy, can be obtained when needed to begin an investigation. This is not when you have probable cause to execute a search warrant. It's when you're starting out in an investigation. The second program is the 702 program. That's content collection. And the critical point about this one is that it's focused on international communications. And this is conducted under an amendment to the Foreign Intelligence Surveillance Act that Congress passed in 2008. And this is the successor, if you will, to the warrantless surveillance program that President Bush initiated after 9/11. And just to get to the bottom line on the Fourth Amendment, this is a search because it does involve content. It does involve reviewing private communications. But the critical point is the foreign intelligence focus and the international aspect. It's focused on non-U.S. persons, which mean not U.S. citizens and not lawful permanent residents, who are reasonably believed to be outside the U.S. in their international communications. And the courts have been consistent, although the Supreme Court has never reached the question, that this kind of search does not require a warrant under the Fourth Amendment to be a reasonable search, because it's conducted for national security purposes and focused on international communications. And in fact, this whole category of communications was originally intended by Congress to be completely excluded from the Foreign Intelligence Surveillance Act and did not require any court approval. That changed when technology changed out from under the Act, and the Act essentially was overtaken by events when communications changed in their technology, and these court approvals were required. And when 9/11 hit, the FISA process became obvious. A serious impediment to our ability to do the surveillance of the foreign members of al-Qaeda and suspects that we saw, that we needed to do to protect the country from potential follow-on attacks. So the president did the warrantless surveillance program. The New York Times reported on it, and there was a great controversy and debate in the country. Interesting history lesson, though, I think. Nobody was impeached. Nobody went to prison. What happened? Instead, Congress changed the law and effectively codified these authorities in the Foreign Intelligence Surveillance Act, but involved the court in approving the program of surveillance focused on international communications. And that's the second program that has been disclosed by the Snowden disclosures. And the fundamental point there is it is a search, but it is reasonable under the Fourth Amendment, because the Fourth Amendment does not require a warrant for all searches to be reasonable. And in particular, when you're focused on international communications and it's done for national security purposes, focusing on a foreign threat. There's a lot of discussion about changing the law and restricting what the NSA is doing. I think we'll probably get into discussions of that further in the back and forth on the panel. And those are critical issues. And this national debate is extremely important. And so I look forward to hearing what others say and to having a further discussion.
Great. Thanks, Judge. And I also want to say to Devon and the rest of the University of Florida Federalist Society, appreciate you guys putting on the symposium. As somebody who is a Federalist Society member, as a law student as well, I know it's hard to do this. You got your day job of studying and trying to get through law school, and then also to put on a big production like this, which we never did up in Chicago, but I went to some of these, and it's a big job, and I appreciate you guys doing this, and we're excited to be here. And I think, as both the judge and Steve have said, these are really critical issues, and it's great to have a discussion with this range of people you'll be seeing over the weekend. A couple caveats or clarifications, caveats before I start. One, I just did want to underscore, I'm the former general counsel of Facebook, former, not current. I saw at least it says former here. I saw in one version of the program today, it still had me as Ted Elliott of Facebook. And you know, when I was still at the company, when I'd give speeches and remarks and panel discussions, I'd give that perfunctory preface about, you know, these are my views, not necessarily those of the company. I didn't really think, it wasn't clear I could really get away with that, right? It's not clear that that's true, but now it actually is true. So nothing, Facebook can disclaim anything I say, and this should not be chalked up to the company. This is just the views of a has-been, washed-up former tech company exec who happened to be involved in some of this stuff during my time. So my comments will be informed by my experiences at the company, but again, I'm not there anymore. And then the other piece I'd mentioned is, as you look at the lineup here, I imagine the thought was, hey, let's get somebody from the tech world to speak on these issues. And yes, again, I'm a in some sense, a representative of the tech world, but in addition to me just being one guy and these just being one guy's views, I would emphasize that the tech world can cover many different areas. And I think, so mine obviously is sort of, you might call it just the internet space. It's, cloud computing, messaging, networking, whatever you want to call it, we'll just call it internet. So I can give one man's internet company perspective, but importantly, I don't have the perspective of a telephone company lawyer or person or a security company lawyer like RSA. Some of those, somebody from those companies might have a different view on these. And for example, my comments will be really focused, at least in my opening, on the 702 so-called PRISM stuff, as Steve broke it down, rather than on the metadata. So anyway, with those as background points, there's really just two main themes I want to get out first here. One is, I think so much of, it's great that we're having the debate. I agree with Steve. I think it's a great debate for the country to be having. My only comment on the debate is that, the news reporting here on the 702 PRISM issues, particularly in the very first stories about PRISM and 702, at the time not called 702, not referred to in the stories as 702, but called PRISM, that reporting was wildly misleading and inaccurate in the most central respects and most inflammatory respects of the reporting. And that was a shame, because whatever you think of the leaks, but whatever you think of them, even if you think that the leaks are good and we should be having this debate, it would have been far better had the initial stories not been so fundamentally inaccurate in key details. And this is one of the things that, as I'll explain, we sort of dealt with at the companies, at Facebook and at other companies. But I think that the hype and hyperbole and inaccuracies about the 702 programs and PRISM clouded the ability to discuss these issues rationally. And specifically the issues of government requests for user data and what the proper scope of those should be, and the basic privacy versus security balance. And so I'd say the debate that's occurred over the past several months, unfortunately, has been hampered by the really shoddy initial reporting that came out really in the first day. It was really the first day that this came out, and I'll walk through that a little bit. And many of you probably read this, but I don't know that many people focus on the corrections or the shift in the story over the first couple of days. But I remember we were, I think the sequence was on one day in June, the revelations came out about the telephone metadata program, and that's been out there for several years, but it came out again. And then I think the following days when we got called by the Post and Guardian and saying they're saying, hey, we're about to run with a story about PRISM. We said, what the hell's PRISM? Never heard of this thing. But and then they ran with the story. We gave the denials. But the Post, and just quoting from the Post here, the Post's initial online story on that afternoon was this. One of the key paragraphs: the NSA and the FBI are tapping directly into the central servers of 9 leading U.S. internet companies. The technology companies which participate knowingly in PRISM operations include most of the dominant players of Silicon Valley. From inside a company's data stream, the NSA is capable of pulling out anything it likes. Okay? The Guardian made similar claims in its initial stories. Similar claims to that, and then added as well, the PRISM program allows the NSA to directly and unilaterally seize user communications off the company's servers. So that was pretty inflammatory, and to me, the key allegations and insinuations in those first stories are collusion between companies and government, direct access, suggesting, I think to me and many others, unreviewed by any court, and bulk access, and also affecting millions, if not tens or hundreds of millions of users, just a big pipeline into the companies. As one CNET writer remarked around the time, he said, these stories cause near panic among the more privacy-sensitive users of web-based email and social networks, and led to speculation about whether the NSA was secretly vacuuming up billions of user profiles from the web companies. So you had those stories out there which were wrong, as became clear pretty quickly. But at the company, from the company's perspective, these inaccuracies and these sort of gross misstatements of what's going on were compounded by the fact that the companies couldn't speak in any detail about what in fact was happening because this is classified stuff and only certain people at the companies are clear to know about this, and then you can't talk about it at all. So that hampered the ability to push back. So we, along with all the other named companies, gave denials that said this is wrong, and then the fact that we denied it without any level of specificity added to the conspiracy theories. So people said, wow, these denials are just blanket denials, they don't get specific, and the companies must be further colluding and coordinating their statements with the NSA to figure out, to make them sound so similar. So it got off on a bad footing that way. And then, so when, about 2 weeks later is when we actually got a breakthrough. This is what the judge mentioned in his introduction. Is we did receive from the government the ability for the first time to include in these reports that the companies do, these so-called transparency reports. We received the ability to include we'd give these numbers, companies would give the numbers of government data requests for user data that we had received worldwide in a 6-month period. Up until that time, you couldn't include in that figure the national security requests. You had to just say law enforcement requests. So we got the ability in response to this to include the number because we wanted to show that we're not talking about hundreds of millions or tens of millions. We're talking about low numbers. So in mid-June, about 2 weeks after the stories initially broke, we were able to get out, and Microsoft got out, and others got out some of the numbers. And just to, the Facebook numbers, for example, were in a 6-month period on a user population of 1.1 at the time, 1.1 billion monthly active users. On that user population in a 6-month period, the total number all in of data requests from any government anywhere in the world, state, local, federal, foreign, national security, law enforcement, the total number on that big user base in a 6-month period was 10,000 requests, 10,000, for a total of between, we could only give it in ranges, 18,000 to 19,000 users. So we're talking not hundreds of millions, not tens of millions, not millions, not hundreds of thousands. We're talking about a fairly small number. However you want to calculate it, some small fraction of 1% of our users are ever subject to this. At the time, we couldn't break out between law enforcement versus national security. We wanted to do that. The government finally granted about a month ago to the companies permission to break out between those two numbers. Again, at some ranges, and now I'm an outsider. I'm just reading what I see now, but according, for example, to Facebook's report that they put out a month ago, of that roughly 10,000 number of requests and 18 to 19,000 users covered by those requests, approximately, again, it's tough to tell from the numbers, but approximately 1,500 are U.S. national security requests, covering about somewhere, if you try to calculate the numbers, something like 5,500 user accounts. So again, getting back to the point, which is the wild inaccuracy and wild hyperbole of the initial reports, I think, I think just imagine how different the debate would be in the initial stories. It would have been if the point had been something like pursuant to congressionally approved procedures approved as recently as, I don't know, 2011, 2012, in a debate, U.S. national security officials have over the past 6 months sent, after going through a court process, to companies like Facebook and Google a couple thousand requests for data about some 10,000 or so users. Let's have the debate. Still, that's great. Let's have the debate about whether that's too much, too little, just right, too much information. But it would have been a very different debate if the papers had gotten those key details right. I would mention that the papers, in what I took as a tacit admission of the gross inaccuracies, they changed a lot of the key details and backed away from many of those accusations, not just weeks later, but really overnight. So by the time the print version came out the next day, many of the stories have been changed in response to the denials that we had given and some, I think, concern at the Post and Guardian that maybe they'd gotten some of those key details wrong. Of course, nobody reads the print editions anymore, so the damage had been done, and this big story was out, and the blogosphere was erupting, and the train was off and running and nobody was reading the correction. So that was a shame in terms of, again, if we're going to have the debate, let's at least have the accurate debate. So that's point one, and I hope that provides some clarification about the numbers we're talking about when we think about the 702 and PRISM issues. Second point I want to make was just the, it's hard / impossible for any one person to give the perspective of the internet community or the internet companies or the tech companies especially. But here's my take on it. I think there's, partly because of the misleading nature of the initial stories, there has emerged over the past few months a tendency to view the internet companies and the government as really pitted against each other, outraged by the internet companies and counter outrage here on the government side. And there's been some of that. You have one image that comes to mind for me is the White House meeting in December, whenever it was, between the internet company execs and the president, where the images of a standoff over with tech company execs demanding additional constraints on this. Although I have to note, judging by the smiles in the room, I think a lot of the tech execs there were very pleased to be getting a Roosevelt Room photo op with the president, especially a president that many of them had supported. So, but there's that image at least of this sort of battle between the two, and with, and even internet companies often get criticized, of course, for being, for playing fast and loose with privacy and not sufficiently defending privacy when they treat people's data, and we can get into that later. But here, there's this, I think in this debate, there's this sort of polarized dynamic that at least is the image. You also see, my old boss, Mark Zuckerberg, saying things like, hey, the government really screwed this up in the NSA stuff. He said that as recently as last week, and that's been a quote you've seen a bunch from him. And, the government has seemed to be firing back. President Obama, in his January 17th speech, made a little dig at the internet companies for complaining while at the same time collecting a ton of data about users. But I think part of this, what I'm going to say is that I think that polarization is not an accurate reflection of the way the tech community thinks. If the portrayal, the sense you get is of an internet community, internet company leaders at least, that are outraged and sort of pro-privacy, at least with respect to the government, pro-privacy, absolutist, indifferent to security concerns, and on the government side, the opposite, just absolutist on security, indifferent to privacy. And certainly on the internet side, that's not. I think that's increased. That's not the case. And some things I've mentioned to help you think about this. One is, internet companies are rightly wary, and historically so, and as lawyers of the company, you fight often against government overreach and attempts to overregulate and stifle innovation at the companies. So the companies are very wary of that and very wary of the tendency for government to go wrong. And the companies are unquestionably and legitimately strong proponents of free expression and freedom generally, which is not simply because it's good for business to encourage people to use your services and have freedom to speak there, but also it does coincide with the worldview that led people like Zuckerberg to start up these companies. So that's, although they have that, companies are also realistic about this stuff and understand that, no internet company wants to be known as a haven for illegal activity. You want to keep your users safe, and you don't want although you want freedom of speech and so on, you don't want your service used by bad people to do bad things. For example, no internet company wants to be known as a haven for drug dealing, for gang activity, for child pornography, or for terrorism. So I just look at it in that realm. So I think and therefore companies are sensitive to the security needs and have to balance that against the privacy needs and the freedom needs. And I think you've seen, it's also not lost on the companies that many of the bad guys that governments are going after when they seek data requests are bad guys who are trying to do harm to the companies hackers, for example, their users by stealing bank data and so on, the internet generally, or the cause of freedom generally in the world, and that a lot of the guys that are the targets of these investigations don't wish well to Facebook and other internet companies. And so the point is, you've seen more of a balanced view emerging these days. And I think I mentioned Zuck's comments about the government screwed up, and that's the one that's highlighted. But in the very next sentence, he always says, the government's job is to protect all of us and our companies and our freedom. Mark Andreessen, the Silicon Valley legend, who is also on our board, recently had a whole series of tweets having a more balanced view of the NSA and saying, these guys have a job to do. It's important. It's important to the robust functioning of our community. So Silicon Valley, I think, is not the absolutist anti-security, indifferent to security body, that the collection of people that they're sometimes portrayed as in this debate. I think some of that stems from my first point, which is how bad the stories were and how inaccurate they were. They were so bad and so inflammatory and so damaging in their allegations, even though those allegations were, as discussed, flat wrong, that the companies had to be seen as really protesting and keeping protesting and hammering the table even more. So I'll leave it at that and leave the rest for Q&A, but I did want to convey that perspective on the community. Okay. Thanks, Judge.
Thank you. Julia? Actually, I got to asterisk this just slightly here. So first, when he says, well, it's not millions of accounts, it's only tens of thousands, it's about 2,000 wiretap orders granted every year for all criminal investigations. So when they say, well, one company has on the order of tens of thousands of accounts flagged for interception, the benchmark maybe shouldn't be millions, but what we do in other contexts. But also when they say, well, this bulk access isn't happening through PRISM, it's true. It's mostly happening through the other component of 702, which is the upstream collection off the internet backbone, and then overseas under the authority of Executive Order 12333, not part of FISA, at the data links between the overseas data centers the companies maintain. So this is why it's always really important to listen carefully when Jim Clapper says, under this program. I said, we're not doing that under this program currently. End asterisk. Actually, I wanted to note that it's actually the timing here is pretty propitious. Tomorrow is actually the 43rd anniversary of the burglary of a FBI field office in Media, Pennsylvania by a group of anti-war activists. Burglary that led ultimately to the exposure of COINTELPRO, an FBI program targeted at spying on and infiltrating domestic dissident groups, peace activists, civil rights groups, other groups of that sort, led in time to the creation of the Church Committee and the Pike Committee, which exposed really several decades of abuse of intelligence authority for fundamentally political purposes under presidents of both parties, including an NSA operation called Shamrock, which involved the bulk acquisition of international telegrams, which were then computer searched for names on a government watch list, including such dangerous characters as Jane Fonda and Muhammad Ali, and maybe most notoriously the J. Edgar Hoover's decade-long campaign of surveillance and harassment directed at Martin Luther King and the Southern Christian Leadership Conference. Sort of most dramatic result of that being that illegal bugs of King's extramarital assignations resulted in recordings, and a highlight reel of his extracurricular activities was sent to his home along with a note darkly threatening that he would be exposed unless he did the right thing and removed himself from public life by one means or another. Also, somewhat more prosaically, provided enormous amounts of political intelligence to Lyndon Johnson. It was useful in plotting strategy at the Democratic National Convention. And, of course, not all of the abuses that occurred during that time are known. Historians have found, for example, routing slips of illegal wiretaps conducted by the FBI that were part of larger archives that were entirely destroyed. So we know from the existence of a few that escaped destruction that the scope of illicit surveillance was larger than we know specifically now. This is in large part because when they were deliberately abusing the law for political purposes, abusing their powers for political purposes. Elaborate steps were taken to conceal that activity from overseers. So, for example, there was something called the June Mail Protocol, which meant that essentially reports on stuff that they weren't supposed to be doing were marked June, so they could be routed separately, not filed in the central FBI system, and instead delivered directly to J. Edgar Hoover's personal and confidential file, which included things like the fruits of Operation Sex Deviant, which gathered salacious tidbits about homosexuality and other odd sexual habits of prominent persons that the FBI might find useful for one purpose or another. I think a couple things come out of that that are relevant to our modern debates about privacy and security. One is that you probably should not expect abuses to be immediately apparent when they occur as part of highly secret intelligence programs. You should expect, in fact, that inadvertent violations of law will be detected, but that people deliberately abusing authority will take steps, because they're not stupid, to cover their tracks. And so instead, it's important to think sort of architecturally about what kind of structure you're creating, not this program or that program, but whether in toto the powers the intelligence agencies have would fundamentally undermine democracy if they fell into the hands of someone like Hoover, who was determined to misuse them for political purposes. And also, more generally, that we should think of, and you'll never hear someone from the Cato Institute, I think, say this on any other occasion, think in less individualistic terms about privacy rights. We understand really, I think, fundamentally with the First Amendment, that there are really two aspects to it. There is, on the one hand, the interest that we have in protecting the right of an individual to speak, rooted in their dignity and autonomy as an individual, but also a kind of structural or collective interest in having a free and open debate in a society where the people are ultimately the source of authority backing the government. And so, in some sense, whether or not I have anything controversial to say, I benefit, living in a democratic society, from a structure that does not allow the government to determine which speakers are going to be heard, indeed, even if I'm not that interested in listening to them. And we think in these more structural terms, I think the question we often hear asked, well, if I don't have anything to hide, what do I have to worry about, becomes in some sense much less relevant. It's probably true that the NSA isn't that interested in you if you're not Martin Luther King, but if they're spying on Martin Luther King, that may be of interest to you whether or not your conversations are picked up as part of the process. On the flip side, when we talk about the security interest, I think it's interesting the way these balancing discussions tend to happen. You usually have on the one side the particular invasion at issue with a particular program, so the collection of telephone records or the collection of international communications, and on the other side the full weight of the entire national security interest in preventing catastrophic terrorist attacks. And this seems to me like a not very helpful way to discuss it. If every particularized invasion is always weighed against the full interest in preventing a nuclear bomb from going off in New York, privacy will lose on every occasion. A more helpful way to think about it, I think, would be something like, all right, if the annualized risk for an American of dying in a terror attack is 1 in 2.5 million, which is one estimate I've seen, does a particular program, let's say the bulk collection of telephone records, reduce it relative to more targeted collection of telephone records by enough to justify that invasion? Is it a reduction from 1 in 2.5 million to 1 in 3 million or 1 in 2.51 million? That would be, I think, a more useful discussion to have, in large part because when we look back at the track record of the programs we've seen disclosed over the past decade, they often don't live up to their initial billing. So we may recall that in the aftermath of that initial New York Times story about the warrantless wiretap component of the larger Stellar Wind program authorized by President Bush, we heard Dick Cheney, among others, saying that this was a program that had doubtlessly saved thousands of lives and averted numerous catastrophic terror attacks. About 5 years later, the Inspector Generals of the intelligence community looked into it and found that the intelligence officials they spoke to were hard-pressed to identify concrete intelligence successes attributable to the program. In other again, anonymous interviews, a lot of officials connected to that program have suggested that, in fact, it did not produce any really unique intelligence, and that a lot of the success stories cited on behalf of this program involved people who were already under surveillance by traditional methods, targeted FISA warrants that the FBI had applied for and secured. This is actually a pattern we see over and over again with respect to fusion centers, which are kind of information sharing hubs. For years, they were touted as a centerpiece of our counterterrorism strategy, an invaluable and proven tool, until a 2-year Senate investigation concluded that they had effectively never produced any important intelligence leads, and in fact were mostly generating reports unrelated to the subject of terrorism, and to the extent that they did produce such reports, it was mostly red herrings that wasted investigative resources. We find with respect to the 215 program, which again was initially touted as being responsible, along with other programs, with averting or disrupting 54 terrorist incidents. This is sort of like saying my cancer was cured by quartz crystals along with chemotherapy. It later turned out that, in fact, the 215 program was used in about a dozen of those cases, and then it turned out that, for the most part, the 215 program didn't actually provide any new or useful intelligence in those cases. There was this one case where someone who had donated a few $1,000s to the Somalian terror group Al-Shabaab was later convicted on a material support charge, was probably identified somewhat more quickly than he would have as a result of a tip from the metadata program, but you do have to question whether one material support conviction is in the course of a decade is actually a sufficiently robust success to justify the bulk acquisition of millions of Americans' telephone records. And I could go on this, but the pattern we seem to see again and again is that the benefit of the most controversial programs is sold very heavily with dramatic claims initially that over time seem not to pan out nearly as well. I'll say a couple quick things, though, about the two specific programs that Stephen Bradbury mentioned. So this is the telephony metadata program, which again is, I recommend Rachel Brand's Privacy and Civil Liberties Oversight Board report on this, but I think is both legally and empirically really useful, in part, again, because it, I think, undermines the claims of absolute necessity relative to, again, more targeted and conventional acquisition of telephone records, but also because it's just part of a broader trend from, again, the kind of traditional method of targeted, particularized acquisition of information about people that there is some basis of suspect to essentially large-scale bulk acquisition of information in order to detect which individuals require further scrutiny. And that's a departure that I think is pretty troubling in the absence of evidence that the more traditional and targeted method is inadequate to the task. In part, the move to this method has been facilitated by the third-party doctrine, which Stephen referenced. This is dates from the late 70s, a couple of decisions, Smith v. Maryland and United States v. Miller, premised on the idea that you surrendered your privacy interests in information held by third parties like the telephone company or your ISP. In part, the strange premise here is that by allowing anyone else access to your data, you've assumed the risk that they will turn it over to the government, and therefore there's no Fourth Amendment violation when the government compels them to turn it over, which is very strange. I don't know why this hasn't been applied to licensed warrantless searches of homes, as long as you have a spouse or a roommate who could let the police in if they decided to. But also, I think, the technological shift that we've seen since then has radically altered the implications of that. Even when you're just talking about individual phone records being acquired, there's an incredible amount of sensitive potential information in that, as long as the NSA has a phone book and can reassociate those numbers with names. It allows them to know who has phoned a divorce lawyer or a suicide hotline, a substance abuse counselor, an abortion provider, who is making cell phone calls and sending texts at 2 in the morning that may be indicative of an illicit affair, and also reveals social networks that can be indicative of political activity. When you add to that the kind of information kept by internet providers or that flows through the internet backbone, which includes in effect a record of almost everything you read, where physically you are on a moment-to-moment basis, the unanticipated effect of that ruling is to essentially strip Fourth Amendment protection from data that is in many ways more sensitive than the contents of the communications themselves. Section 702 is in effect a general warrant. We're supposed to, I think, feel reassured by the fact that Americans are not targeted, though their communications are intercepted. But of course, you're not the specific target of any general warrant. That's what makes it a general warrant. And it's not much consolation that you were not the target if your communications can in fact be intercepted not at the order of a neutral magistrate, but at the discretion of an NSA analyst. And the scale of these, I think, makes it very difficult to police the system for misuse of that data. But also the public understanding of how that program operated, I think, was fundamentally inaccurate. Not just the public's understanding, but the understanding of the Supreme Court in oral arguments presented in the case of Amnesty v. Clapper that came down a couple of years ago. Much of the public debate on this program presumed that, yes, an American's communications could be intercepted if they were in contact with a foreign target without a warrant. We later learned that in fact, your communications could also be intercepted if your communication mentioned a foreign target or a selector on which the NSA was operating. So, in effect, the NSA is filtering all international communications and flagging those emails and other digital communications that mention a target, whether or not the target is actually part of the email. Since a target can also include a corporate entity or an entire website, if a foreign intelligence target is an entity like the Pirate Bay or WikiLeaks, the potential for enormous scale interception of American communications is fairly clear. And so again, to back up to the balance question, I think the question we need to ask is not what particular abuses have we found out about to date, although there's a troubling suggestion that radicalizers who are basically non-terrorists who speak critically about the U.S. and justify violence against it should be basically targeted by campaigns of discrediting by using intelligence about their private online sexual activity. But I think, again, the question we need to back up and ask is, if someone with the intentions of a Hoover once again gained access to this, what effective limits would there be on their ability to use this architecture, which involves massive scale collection of internet communications, enormous collection of not just a telephone, but also various types of financial data that paint an incredibly detailed portrait of anyone's life sitting in a database waiting to be scrutinized and searched, and according to some of the student documents we've seen, now legally available for search using U.S. selectors, even if the initial acquisition is targeted at foreigners. So once that information is collected, the NSA is now allowed to go in and search for an American's name, even though, of course, they would have needed a particularized warrant to do initial collection targeting that person. What are the practical limits on that, on the misuse of that vast store of data? Given that the FISA court has itself been misinformed about the technical details of how these programs operate for years at a time, I think the answer has to be not very much.
Rachel?
Thanks, Judge Pryor. It's really good to be here. The FedSoc Student Symposium is one of my favorite events. I went to it all 3 years when I was in law school, and I, in fact, met my husband at the first one I went to, so look around, you know. Maybe you never know what could happen. So anyway, it's good to be here in Gainesville. So the problem with going forth is that everything's already been said, so I don't know what I'm going to say here, but I'm here in my capacity as a member of the U.S. Privacy and Civil Liberties Oversight Board, which is a brand new federal agency most of you have probably never heard of, and so I thought I'd start out by telling you what we are and sort of put us on your radar screen, and then I'm going to do a couple of sort of high-level kind of food for thought points for you. So the 9/11 Commission, you know, much of the report was about intelligence failures and about how the government needed to do better in connecting the dots and preventing terrorist attacks, but at the same time it said that there should be somebody watching what the government does to make sure that you know, the government doesn't go too far and violate privacy and other rights. And so it recommended that there be a board, an independent board, to serve that function. So in 2004, a board was created in the White House of, you know, 5 sort of distinguished people to take a look at these issues. But that board was soon disbanded because there was a perception that being in the White House, that board was not independent enough from the intelligence community agencies that it was supposed to oversee. So in 2007, Congress created my board, the Privacy and Civil Liberties Oversight Board. We go by the acronym PCLOB, which when we met with President Obama recently, he said it sounded like something you don't want to catch, which I thought was kind of funny. Anyway, so we're the PCLOB, and we are our statute says that we're an independent agency in the executive branch, so we don't have any parent agency. We're not part of Justice or, you know, state or DOD or anything. We're independent. We're a 5-member board. We're all appointed by the president and confirmed by the Senate, and we're bipartisan. So the president has to appoint at least 2 people from the other party. So I am a Republican Obama appointee to the board. Our chairman is a full-time government employee, and the other 4 of us are part-time. So we serve on this board besides whatever else we do for a living. And our mandate is twofold. It's to provide advice and recommendations to federal agencies when they're formulating counterterrorism policy, and then to do some oversight on the back end. Our mandate is limited to counterterrorism, and it's limited to the government. So we do not oversee Facebook or any private party. We just look at what the government does. Now, when Congress created us in 2007, it thought it was beefing us up from the previous iteration of the board, but in fact it killed us for 5 years because nobody was ever confirmed to the board until 2012, when 4 of us, including me, were confirmed. The 4 part-timers were confirmed. And since we're a new independent agency in the executive branch, we had no staff, we had no full-time chairman, so the 4 of us part-timers were trying to set up a brand new federal agency from scratch in our spare time, and it was very slow going until our chairman was confirmed in May 2013, right before the Snowden leaks hit. So he gets confirmed, you know, I think it was days later when the first Snowden leaks hit the press, and right away the president and numerous members of Congress asked us to investigate 2 of the leaked programs, the 215 program and the 702 program that have already been discussed. You know, with no staff, and you know, in the beginning we were using Gmail accounts, and it was, you know, we've sort of come a long way from there, but it was challenging. But in January we put out a report on the 215 program, assessing its legality and its policy and privacy implications. Julian referred to it as Rachel Brand's report. I would not refer to it so, because I actually dissented from the key recommendation in the report. But what the majority of the board said was that they thought that the 215 program was unlawful. They think that the statutory language does not support the program. The 215 actually refers to a section of the Patriot Act. It amended an underlying provision of FISA, the business records provision of FISA, and it's basically a subpoena authority in FISA. And it's something that the government normally uses to get, you know, I don't know, Steve Bradbury's, you know, some specific document about a particular person. But the telephony metadata program was a bulk use of Section 215. So my board thought that that bulk program could not fit within the language of the statute. And the board also thought that, looking at the policy implications, they didn't think that the intelligence value of the program was very great, and they thought that the privacy implications were great, and so as a policy matter, they recommended shutting the program down. I dissented from both of those grounds. I think that the statute does support the program, although I don't think it's the clearest cut question I've ever seen. And in terms of the policy implications, you know, I think there's a real problem when sort of after the fact you look at whether an intelligence program has been the sole factor in thwarting a known terrorist attack lately, which is basically the standard that my board applied. Intelligence programs are preventive. They are inherently long-term in nature and forward-looking. If the program could, prevent the next 9/11 tomorrow, that's value even if it hasn't done it yesterday. So you can't look at sort of a snapshot in time. So, I had various issues with that report, and I'm not going to belabor 215 because so much has already been said about it. My board is now looking into Section 702, and the difficulty for me in discussing that is, first of all, I have an active security clearance and we're in the middle of an investigation on 702, and most things about that program are still classified, unlike what's the case with the 215 program. So I'm going to stay away from discussing that program here. So I want to make two kind of high-level points, and I've overheard a lot of conversations today that lead me to a few conclusions about this audience. So I think you are highly educated, I think you are well informed, I think you are highly opinionated, and I think that you don't at all agree with each other on these issues. And so I suspect that many of you probably don't agree with me, which is great, it's fine. But I think that there are probably going to be a lot of late night debates over drinks or whatever, and over dinner tomorrow, the whole weekend. So here are a couple of things to think about as you have those debates over drinks. The first thing is that it's very frustrating to have these debates because so many of what go by purport to be facts are just completely wrong. And Ted already went into this in a fair amount of detail. But this is not a new problem. I mean, when I was at the Justice Department doing counterterrorism policy, including working on getting sections of the Patriot Act reauthorized, it was unbelievable how wrong most of the reporting about the Patriot Act was. If there was a policy somebody didn't like, it was definitely in the Patriot Act. It didn't matter if it even existed, if it was a counterterrorism policy or anything, it was definitely in the Patriot Act. And so it made it almost impossible to have sort of a reasoned legislative debate about that reauthorization. And I find the debate about this program is maybe a little bit less preposterous than it was about the Patriot Act, but there's still just a lot of factual inaccuracies in the press about the programs. So as you're trying to develop your opinions, try to get the real facts. And just to take 215 as an example, if you read the press and if you read the blogs and if you look at what some of the NGOs say about the 215 program on their website, you would think that either the NSA is listening to your phone calls, or at least the NSA has a pretty good idea of whether you've called your doctor, your lawyer, your priest, the suicide hotline, or whatever, your mistress, whoever. And that's just not remotely close to the actual facts. If you think about what the 215 program is, it is a collection of phone numbers and the times they called other phone numbers. And then those are put in a database, the vast, overwhelming majority of which will never be looked at all. There are no names in there, there's no addresses, no credit card information, no personally identifying information at all, just a bunch of numbers. Now, if the government has a particular number that they have evidence is connected to terrorism, then using extremely strict safeguards, they can do a query of the database to see which number is called that number, okay? Now you can all draw your own conclusions about the privacy implications of that. I know lots of different opinions about that in this room, but you have to at least start with an understanding of what the program is. So that's point number one. Point number two is that I would encourage all of you to think about what you think privacy is. And I was actually really interested in Julian's comment about making things less individualistic, because part of the difficulty when you're doing policy on privacy, and I set aside the Fourth Amendment, there's a pretty well-defined view of what the Fourth Amendment protects. It's an objectively defined, reasonable expectation of privacy, and there's a lot of law on that. But if you go into the policy realm, which is where I focus in my board capacity, there is no generally accepted view of what privacy is or what interests are protected by privacy. So the other day I was at a dinner and I asked a leading privacy thinker, what is privacy? And he said to me that it is every individual's right to protect, to control information about him or herself, which is a personalized, subjective standard that in my view is impossible to craft public policy around. Now there could be lots of different interests that could be protected by privacy that I want to sort of lay out as sort of a menu of options, and maybe privacy means all of these things or some combination thereof. But one thing that it could be is your ability to keep secret information that could embarrass you or that could harm your reputation. That's usually the most kind of intuitive idea of privacy. That's pretty subjective, because what might embarrass me might not embarrass you. And for the students in this room, you all put a lot more stuff about yourselves online than I ever would. So I think that, again, there's a generational difference and there are individual differences there. If that's the interest you're protecting, is it affected if information about you is collected, but that could affect your privacy if disclosed, but it's put somewhere and it's never looked at? Is that an actual injury to that privacy interest, or does that just create a risk of injury to that privacy interest? Or take it one step further, what if somebody looks at it, but that somebody is nobody you'll ever meet, or nobody that you'll ever have contact with, or nobody that can really have any effect on your life? Is somebody behind the, the green curtain looking at information about you that you'll never meet, does that injure your privacy? Another way of looking at privacy might be keeping secret from the government information that the government can use to impair your liberty. Now, that conception of privacy really only applies to the government. It doesn't apply to Facebook or Google or anyone who's collecting a lot of information about you for commercial purposes. It could also apply to virtually every piece of information collected by the government. So that's another aspect of privacy. A third one could be keeping secret information that could harm you financially. Now, the most obvious thing there would be, credit card information, banking information, but it could also be medical information, if that information could be used to discriminate against you in provision of insurance or something else. It could be any information that could get you fired, and what could get any particular person fired depends on what job they have, right? So it's hard to kind of craft rules around that conception of privacy. Privacy could be protecting information that affects your security, your physical security. And then if you go in Google privacy, you'll see there are lots of other definitions, some of which are as broad as the right to be left alone, the right to autonomy, the right to just self-control. And that definition of privacy affects every single thing that the federal government does. So again, it doesn't really provide a useful set of rules to decide if I have X set of data, I'm the government agency and I collect a certain type of data, what do I do with it? What can I do with it? How should I protect it? Who's allowed to see it? Or can I collect it at all? So those broad concepts of privacy don't help you make those public policy decisions. So that's just some food for thought. Happy to take questions on that in the Q&A.
Thanks very much. I feel a little bit like a fraud being here. I have to admit right off, I don't know a whole lot about national security. And as the father of 3 young kids living in a small house, I know nothing at all about privacy. But I do teach the Fourth Amendment, among other things, and I thought maybe I'd take my brief few moments here to give a little bit of background on the Fourth Amendment. Now, obviously, these discussions are not just about the Fourth Amendment. They're also about policy considerations as well. But I think the Fourth Amendment concerns kind of frame the policy considerations, and they're worth thinking about. Now, a couple other things. In my own scholarship, I like to focus on the text and the history of the Constitution, and so it's worth taking a moment to look at the text of the Fourth Amendment, which says, I had it on my smartphone, but it's gone out, so I'm not going to. It's something like the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated.
That's pretty good. Where's the Fourth Amendment?
That's at least the first clause. That's good enough. Because that's the only clause I want to talk about, right? So the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, right? So the question is, so point number one of the very first things that we did as a nation when we became a nation was to set up a constitutional right against unreasonable searches and seizures. The other thing to note is that we're a country that had a revolution against our parent country in part because we didn't want the government to go through our stuff, right? That's one of the reasons, one of the main complaints against the British. Also, it's worth noting that the concern over national security is not a new one. From the British perspective, the American colonists were a group of terrorist criminals who presented an existential threat to the British Empire, right? So these are old concerns. They date from the very beginning of our nation, and they're very difficult concerns to deal with. And I'll tell you right off, I don't know what the right balance is between privacy and security. But again, I do want to talk a little bit about how the court has dealt with the Fourth Amendment in recent decades, because I think it demonstrates the ways in which this problem has been developing really since the beginning of the 20th century, right? and it's really a problem that relates to technology. As technology has advanced over time, the government has been able to do things without physically intruding into a person's houses, papers, and effects that are essentially the functional equivalent of intrusions into persons' houses, papers, and effects. And the question the court had to struggle with throughout the 20th century was, is this a search or not? Right? When the government uses a microphone to listen in on your private conversations, is this a search or is it surveillance? Right? What is it? Does it fall within the Fourth Amendment at all or not? And of course, in the famous Katz decision in the 1960s, the Supreme Court said, well, if the government uses a microphone to listen to your phone conversations, that is a search, even though they're not physically intruding into your property, and even though they're not seizing your stuff, it's still a search, and it's governed by the Fourth Amendment. And many people think of Katz as being a great sort of landmark in sort of privacy rights. But there's a sense in which the Katz case was problematic in that it got the court into the game of, is it a search or not, right? When is a search not a search, right? That's the game the court has been playing since the 60s, right? And so I've made a list of some of the highlights. When the government sends someone into your house wearing a wire who broadcasts your private conversations to the government, is that a search or not a search, the court asked. Nope, not a search, right? Because you've knowingly exposed your house to this third party, you took the risk that they might be betraying you. Well, what if the government gets the phone company to put a pen register on your phone so that it can tell what numbers you're dialing from your phone? Is that a search or not a search? No, not a search. You took the risk that the phone company would betray you. And since you took that risk, it's not a search. What if they get your bank records? Not a search, right? For the same reason. You took the risk that the bank would betray you. Other types of cases. What if the government uses a beeper to track your location? Well, that all depends. If they put the beeper on the canister of chemicals before you own it and then track it after you take possession, that's not a search. If they put the beeper on the canister of chemicals after you own it and track it, that is a search. What's the difference? Well, you know, it's sort of, I'm the daddy, right? The Supreme Court said that that's the rule and that's what we're going to follow. What about dog sniffs? Right? If a dog sniffs your stuff to determine that you've got drugs or explosives, is that a search or not a search? Well, if the dog sniffs your person or your effects, that's not a search. If the dog comes up to your front door and sniffs, that is a search. Right? It's a very strange set of cases. And I would suggest, and it's always, I love teaching it because it's kind of fun playing the when's a search, not a search game. But there's a real problem here, which is it deflects us from the real question, which is not whether these things are searches, because they're all searches, or they're pretty search-like anyway, for the most part. The question is whether they are reasonable searches. That's the question that needs to be addressed. And by playing the when is a search, not a search game, the court has been able to evade these questions, right? And of course, it's left open room for things like the NSA metadata program, which is, under current Supreme Court case law, justified, right? In the pen register case, the court said, if you send out your phone number to the phone company, you've assumed the risk that they will give that number to the government. Well, that's all the metadata program really is, right? The court, approved it in the 60s. So we're having debates about it now, but from a Fourth Amendment perspective, that debate was sort of closed off in the 60s because of the when is a search, not a search game, okay? Now, this is a problem, and I would suspect, I would say to you that I don't think this game is sustainable over the long run, okay? And here's why. It comes back to technology. Remember, the reason we got into this game was because of technology, right? There are two problems relating to technology that the court has not figured out how to deal with. One is that the government's ability to use technological surveillance is growing exponentially, right? In at least two ways. And again, I'm not an expert on this, but in at least two ways. Number one, it's becoming much more intrusive. The government can get a lot more data about you than it used to be able to get back in the days of beepers and pen registers, which seem sort of quaint by today's standards. Number two, the government is able to aggregate this data much more comprehensively than it ever could before. So it can know every single thing about your life simply by tracking data that the Supreme Court has already classified as public and thus not subject to the Fourth Amendment, right? So this is something that the court needs to deal with. A couple years ago in the Jones case, which involved GPS tracking, a lot of people thought the government might, or the Supreme Court might take a stab at answering this question, but it punted, as it often likes to do, and came up with this crazy physical intrusion test, which doesn't answer any of these questions about what's reasonable and what is not reasonable. Of course, now there's another side to the changes in technology, which is what part of what makes this such a difficult problem, is that the technology of terrorist attacks has changed, right? We live in a world where terrorists can hijack an airplane and fly it into the World Trade Center, where they could get a nuclear weapon, right? Where they could get, some kind of nerve gas, right? There's all sorts of things that can be done that can cause destruction on a mass scale. So what do we do about that? What do we do about the fact that the technology of surveillance is becoming much more intrusive, but also the technology of destruction is becoming much more severe? How do we balance that equation? And of course, I don't know the answer to that question. That's the great thing about being a law professor. I noticed the tweet. I'm sort of the token law professor. We don't have to answer these questions. We can just sort of pose them and let others debate about them. But I think they're really important to answer. And I think the first step, at least from the Fourth Amendment point of view towards answering these questions, is to give up this game of pretending that searches are not searches and recognizing that they are searches and trying to develop some standards for determining when they are reasonable and when they are not. Thanks.
All right. Very good. Okay. Before we open it up to questions for the floor, not everyone obeyed their time limits tonight, but does anyone have any compelling need to say something in response to another panelist? No? That's good. So why don't we then open it up to questions? We have at least one microphone I see to my left, another to my right. I don't know if there are any others around the room, but identify yourself. Now, those who've seen me moderate a panel before know about this. You can give a little background and introduction to your question, but please have a question. These are the panelists. You ask questions. Okay. Question.
Hi, my name is Alexander Boulder. I'm a student at Florida State University. For Mr. Bradbury and for Professor Siniford specifically, and anybody else who wants to jump in, individuals don't have a reasonable expectation of privacy for their metadata, for the business records. But do the companies have a right to refuse to provide them? Do the companies have a reasonable expectation of privacy for their business records?
Well,
Go ahead.
Yeah, under the FISA provision in question, the companies have standing to challenge a request for any business records that are approved by the FISA court. So the companies can object to the request. They can challenge the relevance standard. They can say it's too burdensome, it's too broad, and then they can get a hearing before the FISA judge and appeal that up to a court of appeals. It's a statutory right. It's not based on the Fourth Amendment reasonable expectation of privacy. They are business companies. They're engaged in business, and I guess I would just say that the question of whether it is a search or not is a critical question for Fourth Amendment purposes, because if it's domestic, if it's not national security, international focused, and it's a search, ordinarily it's going to require a warrant. And if it requires a warrant that's based on probable cause and defines the search with particularity, then all manner of initial investigations of law enforcement departments and agencies engaged in all manner of regulatory activities could not proceed as they do. So it's a critical question for the function of government and for safety and everything else, whether it's a search or not. And if it's not a search, then it's the same answer, whether it's a company or whether it's an individual.
I think the relevant case here is an early 20th century case called Hale v. Henkel, explicitly refers to departure. There's an earlier 19th century case called Boyd that had held that the production of even business papers is barred by both the Fourth and Fifth Amendment. Hale v. Henkel essentially concludes that corporations are creatures of the state, and so there can't be any kind of Fourth Amendment objection to requiring them to produce business papers. Understanding at the time, I think initially was, of course, that these are going to be business records that pertain to the activities of the corporation. And so the government can check whether it's sort of obeying the terms of the corporate charter or the conditions on the existence of the corporation. That ended up being a kind of back door through which was smuggled the ability to get records pertaining to the activities of individuals, which I don't think was contemplated at the time, because now it is so common for corporations to have detailed records about individual activities as opposed to just their own activities.
I'd just like to throw in one more quick thing. I don't want to take up too much time, but it's an excellent question in one sense, which is that it highlights one of the ridiculous things about the court's assumption of risk doctrine under the Fourth Amendment. Because remember, the court says, like, pen registers or the metadata program are okay because you've assumed the risk that the phone company will betray you, right? That does not mean the government has the power to directly tap into your telephone to monitor the numbers. They have to get the phone company to sort of give them the records because they're the one that's supposed to be doing the betraying. Of course, if the government subpoenas the company and tells the company, give us those records, right? That's basically holding a gun to the company's head and saying, betray your customer, right? And then, of course, they do. And then the court says, well, you ran the risk that the company was going to betray you. It's all very silly because really what's happening is the government is compelling production of this information just as though it were directly tapping in to the bank accounts or phone records or whatever it is. The reason that the providers are involved is simply because of this fiction about kind of assumption of risk, which really I don't think makes a lot of sense.
Question from the right.
Hello, my name is Devon Watkins. I'm a student at George Mason School of Law. Given that the third-party doctrine has been questioned by some Supreme Court justices recently, I was wondering, for those pieces of data that are protected by contractual privacy rights, what percentage of Americans do you think would be willing to release them to the world and let anyone know? And if not, if they wouldn't do that, isn't that suggest a reasonable expectation of privacy by those individuals of that data protected by contractual privacy rights?
Well, I just want to point out here that it's not just the third-party doctrine, and it's not a concept of betrayal that is the underpinning for the constitutional analysis here. We're talking about, for the metadata program, we're talking about transactional information that is created by the telephone company in the ordinary course of its business. It reflects a transaction that you've initiated when you send the phone company a phone number. But that's not your information that you control. It's the business information of the phone company is transactional. So it's different from the betrayal analysis, which would affect content of a private communication, like a letter, let's say, that you write and betrays a lot of personal information, and you send it to your best friend. Once it's delivered and the friend opens that letter, it's out of your control. And even if the friend has promised you he'll keep it secret, he could betray you. That's the betrayal doctrine. That's not the principal analysis here. So I just wanted to make that clear.
I'd like to at least gently disagree with that. Certainly the betrayal analysis is not the only rationale used in Maryland versus, what's the name of the case again? Smith versus Maryland. It talked both about assumption of risk, which is the betrayal doctrine, and the limited nature of the information involved with metadata. They were both part of the rationale. But Smith versus Maryland did not authorize the government to directly obtain this information. It had to get it through a third party, and the rationale was that you assumed the risk by revealing this information to the third party. So I do think that is part of the analysis.
I do think it's important for your question to add that Congress in this area, when it comes to communications and private communications like emails, a lot of email gets stored in the cloud, it's stored in computer servers that are out of your control, but it's still your email account, for example. And Congress has provided extra protections by statute. And so there is a requirement that there be consent before it's disclosed, or that certain standards be satisfied. But a court order is an exception to that if there's an authorized court order and standards are met, for example, probable cause for an investigation. So there are protections that are statutory. And I think really what the proper debate here is what those standards should be that are defined by statute. And when do they strike the right balance? When do they go too far in terms of limiting what the government needs to do to protect the country? And so I think that's a debate that we're just beginning as a result of these disclosures, and I think it's a very healthy debate, and I think it's properly one that Congress should address.
Anybody else? Next question.
I'm Sam Miarelli from the Orlando Lawyers Chapter. I'm curious about the sort of suggestion that these are such a small number of searches and probably doesn't affect anyone in the room, when we know that these same powers were used to wiretap American lawyers from Meyer Brown who were advising trade negotiations. And so I just would wonder from the panelists who support the current programs, what limits, if any, you see there could be if known attorney-client privilege communications of American attorneys can also be swept up in these programs.
Well, I think that's, with due respect, an example of a distortion from some of the public press reporting on this. And it's now sort of entered into the national consciousness. Oh, the NSA is listening in to attorney-client privilege conversations. Well, oh my gosh, what could be worse? Maybe that sounds bad to lawyers, I suppose. But in that case, what the facts were was that the NSA provided assistance to the Security Agency of Australia, which was conducting surveillance of the Indonesian government for its own foreign policy purposes. And as part of that surveillance of the Indonesian government, the allegation is, I believe, from what I understand, there was interceptions of communications with lawyers who were working for the Indonesian government. And further, if you read between the lines and what the report is saying, the news report is saying, you see that the Indonesian government reported to the NSA, we think we may have intercepted some communications involving attorneys. And it's pretty clear from the reports that they then masked those communications and did not turn them over to the NSA, did not share that information with the NSA. So there's no indication there that the NSA was using the intelligence agency of a foreign government to indirectly and improperly do surveillance on U.S. persons and specifically targeting communications of attorneys. It's not even clear that the Australian government kept those communications or made use of those communications. But it was the NSA assisting a foreign allied intelligence agency doing surveillance of a third foreign government. And so I think that's an example of some distortions in the press reports that cause a lot of confusion on these issues. Did you want to?
No, that's
Judge, the only thing I'd add, and it doesn't address that because I've just read the Vegas stuff about that, but I did mention the numbers, and it was, the point is, I mean, this is a nice question, interesting. Is even 5,500 in a 6-month period too high? Julian made the nice point that, hey, maybe we should measure that instead of against a user base of 1 billion. Maybe we should measure it against what the normal run rate is of other government data requests. Footnote, my asterisk on that one would be the very numbers show that it's actually, again, we know what the numbers are, at least in ranges. It's 1,500 out of 10,000 are, so the remaining 8,500 are normal, ordinary course law enforcement requests. So it's sort of, and maybe that's too high, maybe that's too low, I don't know. But the key is you can't, the initial stories that set off the whole debate were so wildly inaccurate and suggested, intimated there are millions and millions and millions of these. Again, these are good debates to have, but we've reached a point where we're actually talking facts and numbers as opposed to the hyperbole.
Julie, do you have anything you want to say? No. All right. Next question.
Hi, I'm Shannon. Is this on? Am I not tall enough?
It is. We can hear you.
Okay. I'm Shanna Bailey, Vermont Law. My question is for Ms. Brand. This is policy related. When we're discussing these types of privacy issues, we're really focusing on U.S. citizens, and we have certain protections in place, the Constitution, Congress, and different acts. My question is about what are we using as parameters when we develop policy, when we look to get information out of foreign citizens or foreign heads of states, and how do we go about that without damaging our foreign diplomacy and foreign relations with other countries, which is arguably just as threatening to our national security?
Well, there are a bunch of things embedded in your question. First of all, foreign relations is very far afield from my area of expertise, and I know that the president recently said that he was not going to be collecting on, if you're referring to the Angela Merkel, cell phone stories, that we're not going to be doing that. But there's a broader question that's coming up now in the debate about Section 702 collection about what to do about treatment of non-U.S. persons. So we have, and Professor Stiniford's probably in a better position to address this than I am, but under the U.S. Constitution, there are already some rights afforded to non-U.S. persons inside the United States, some rights afforded to U.S. persons outside the United States, and there's sort of a whole structure that's complicated as a legal matter. And there's the policy question of how to treat non-U.S. persons, and that's something that my board is looking into right now, so I don't want to say too much about it, but one interesting thing to look at is some of the suggestions that international law imposes some obligations on the U.S. government with respect to what it does in collecting information about non-U.S. persons abroad. And there is a debate about whether a convention called the ICCPR has any application extraterritorially. So if the U.S. government's collecting information about, Indonesians in Indonesia, is there any international law obligation whatsoever on how the government can do that? The U.S. government's position has always been that treaty doesn't apply extraterritorially, and therefore there is no international law that applies there at all. But again, that's a subject of some debate. We're looking at it now.
These will be the last two questions. First, here to my right.
Hi, my name is Craig Patrick. I'm from Harvard Law School. I kind of wanted to take a step back and ask about how we go about this debate. So there have been a number of, I also used to work at Facebook, which is why Ted just kind of gave me a look.
Hey, Craig, how are you?
Yeah. How we go about this debate. So when there's a falsehood that the media runs with, it kind of makes it a bad situation. At the same time, it is kind of secret. And then finally, at the same time, looking back at the debate that took place before June of 2013, it strikes me as inadequate. So I guess I'm interested in the panelists' ideas about how we should debate this issue going forward, given the challenges.
Well, I think this is a good example of how we should do it. And I really think, again, I emphasize what I said at the beginning, it's a very healthy debate and a historic debate, and it's happening all over the country. And it's these issues and these types of programs and the way they're discussed and the scope of who participates in the discussion, it's never going to be the same again. I mean, I think this is, these revelations and this national debate have changed the bearings. It's a sea change in terms of how policymakers and elected representatives and civil servants and the intelligence community and everyday Americans approach and discuss and decide issues of national security and surveillance. I mean, I think it's pretty amazing, really. The interesting question will be whether the programs can be effective and sustainable in the hot light of these public debates. And that's, again, a critical question that has to be balanced, and it really is a matter of life or death, I think. In fact, I think for our way of life. But in any event, it couldn't be more important.
There is an asymmetry here, right? So if reporting in the Washington Post gets the details of how a surveillance program operates wrong, the government, after sort of not answering their questions before publication, is in a position to correct the error after the fact. When something the government says about the same programs is either false or extraordinarily misleading, it's usually very difficult to correct the error after the fact without access to the classified information, although that is occasionally possible through, for example, the offices of groups like the PCLOB and the President's Surveillance Review Group.
Judge, sorry,
No,
go ahead.
go ahead, Ted. No, go ahead.
The only thing I was going to say is I think two things will emerge from the past few months, at least in terms of future debates on these. One, I think Congress will pay a lot closer attention to the extent they weren't focused on the details of this. I mean, now they know it's a pretty hot button issue. So I think they will focus more on the details and ask more questions about what they're being asked to authorize and so on. I also think that my take on it would be that the one lesson of this that's emerged has been that the intelligence agencies can be a little more forthcoming while still protective of national security than they were. I mean, take the thing I talked about, which was the number of national security requests. We're sitting here in March 2014. Now the companies can all say how many of these they get, how many of these they receive, and that gives us scope to the problem. And again, maybe that's too high, maybe it's too low of the numbers, but now companies can give the numbers. It doesn't seem there's been who knows, knock on wood, there's not been a major impact on national security by being able to release those. If the NSA used to allow companies to release the number of NSLs that they received, right? This was up until June of last year. Companies could do that, but the government drew the line on anything related to FISA or others. And it seems that we've been able to advance the ball on that one, go in a more transparent direction, share more information in the public debate while still being respectful of national security interests. So I think I would hope that the national security community would be more willing to share more. And this is what Mark Zuckerberg, for example, was getting at by saying, I think the government blew it. They should have been more transparent. We get the interest in security. Okay, that's fine. But be more transparent with people about what you're doing so we can debate it.
Just a couple things. I agree with, I think, part of what Jillian was saying about the government has not done a good job of responding to the leaks in the press and explaining what's going on in a kind of an accessible, coherent way. And they know that. If you talk to senior administration officials, they know that they've sort of screwed up the PR on this. It's interesting, though. I mean, I think 5 years ago, a year ago, you would have said that media relations and the NSA, that was some kind of oxymoron. It's not really that surprising that the intelligence community isn't great at press, but it's not. Another thing that, in terms of the question about how to have the debate, one thing that I mentioned in my dissenting statement from the PCLOB report is that it's really important to avoid these wild swings of the pendulum in national security policy. So you had the excesses that Julian mentioned that preceded the church committee. And then you had the church committee and there's sort of a swing backwards to very strict restrictions. FISA came after that. And then you've got, sort of an accretion of law and policy that make it very hard for the intelligence community to do their jobs. And this is what created the wall that the 9/11 Commission was so concerned about. And then you have 9/11. And then there are incredible recriminations against the intelligence community for not finding it out when they have one hand tied behind their back. And then you've got the 9/11 Commission saying, oh my God, you didn't connect the dots and you weren't sharing information. And the reason they weren't sharing information was because of law and policy resulting from the church committee and that whole outgrowth. So now we're in the post-Snowden era, we're going back in the other direction. That is not good for national security, it's not good for the intelligence community, it's not good for anybody. It's, I think, human nature. It just may be inevitable, but it's unfortunate. And then the other thing is that it's really there's an incredible amount of distrust of the government, and I get that. I mean, I'm a small government libertarian. I don't like what I see coming out of a lot of agencies of the government. And, you know, it's interesting, once you leave the government, you realize that maybe you drank the Kool-Aid a little bit when you were there, and now you see things differently. But in terms of the intelligence community, it has to be said that people in the intelligence community take laws and rules extremely seriously. I mean, the 215 program, the 702 program, they are extremely difficult to use. They are so lawyered. I mean, the number of levels of review that you have to go through to do a query in the 215 program or 702, I mean, it's incredible. Now, I see that because I have a clearance and I go up to the NSA and I see how it works. Most people don't know that, though, so they think that the NSA is just willy-nilly collecting stuff with total disregard to the law and the rules, and it's just not true. And so I just, put that in the back of your mind.
So that is, we hope, true now, though, and one of the opinions disclosed, the FISC concluded that they had been misinformed about how that metadata program operated, that in fact, the vast majority of times the database was queried, something on the order of 17,000. It was through automated processes that hadn't been cleared, and so essentially the very strict safeguards surrounding that program had, as the court concluded, been so systematically violated that essential oversight and safeguard had never functioned effectively.
But I got to respond to that, Julian. I'm sorry, Judge.
We got one last question I want to get to, who's been waiting very patiently.
Here's the thing about that FISA court opinion. The reason the FISA court was addressing that issue is because the NSA reported itself to the FISA court. Right, and so the NSA, whenever they screw up, even if it's the most minor technical thing, they go to the court and they report themselves and the court deals with it. So, yes, that was a screw up, big time, by them. Not intentional, a technical screw up, but they reported themselves and then the FISA court dealt with it. So you have to keep that in mind, too. Sorry, Judge.
That's okay. Last question. Hopefully it won't prompt too extended a discussion. Because we don't want to interfere with mating habits, right, Rachel?
That's the cocktail. That's a separate.
My name is Cassandra Mejias. I'm at U Maryland Law. I guess my question is going back to this idea of a broader understanding of privacy, because we've been talking a lot about individuals and then government. So there's been this talk about these records aren't ours, but it's kind of, what does this have for the effect on speech generally when we feel that the things that we throw out are so easily to be shell gamed and then grabbed, and the government also sort of backdoors any efforts to encrypt sort of maybe our emails or our communications. So we're sort of we're either forced to literally walk into someone's office to talk to them to try to keep it, or anything that goes to the wire seems like it can be kind of shell gamed, especially when their government sort of doesn't really like encryptions that they don't have the keys to and things of that nature. And so how does that fit into sort of a broader idea of privacy as opposed to this sort of individual, I think, look. I don't know if I was very clear where I was going.
Yeah, I mean, so I guess I'll say briefly, in the interest of time, I'll suggest just check out the amicus brief filed by, I think, 21 or 22 groups in the ACLU's case on behalf of First Unitarian, discussing sort of chilling effects and drop-offs in phone contacts they've had in the wake of the disclosure of the program. I think it is part of this collective understanding is important to understand is that we think of privacy harms as sort of paradigmatically involving exposure, when really harms arising from the lack of privacy are often about what is not exposed because it doesn't happen. Right? I mean, the reason psychiatrists' office have very high levels of confidentiality guarantees isn't just to avoid the embarrassment of exposure. It's that without the protection, people who need care don't go to the psychiatrist's office, and that's the sort of invisible privacy harm that is less sort of easy to get your hands around, but is much more widespread than the particular people who end up being surveilled or having their information exposed.
Anybody else?
Can I say one?
Yeah.
I guess I would say one last thought from my perspective, and that is we're all, we're talking about the big bad federal government and the NSA and snooping around in all of our private lives, but I think at the same time we should keep in mind that we're all extremely lucky to live in the United States, where we do have a Fourth Amendment, and this is the only country in the world where our National Intelligence Service has to go to a court and get a court to approve an order that allows them to listen in on private communications of Americans. That's not true anywhere else outside our borders. So if you're concerned that your communications may be being listened to by the federal government, there are lots of procedures and requirements that need to be met before that could be the case lawfully. You can always speculate that there's abuse and unlawful activity, but in these programs, there hasn't been anything identified that is an intentional abuse or an unlawful violation of the law. Outside the borders of the United States, when it comes to national intelligence services, and most of those other countries have them to one degree or another, you have no such guarantees about your communications. So it's just something to always keep in mind, and it sometimes we lose focus of that when we talk about the United States, because this information has been disclosed and it's the focus of the U.S., but there's a lot of other countries out there and a lot of other intelligence services that have not been exposed as a result of Edward Snowden's leaks, but those activities go on. So.
Okay. Please join me in thanking our panel.